Guys, girls, how's it going? Dark Angel here. Hey, so today what I want to do is I want to get into a case that I found. I've known about it for a while, but I've never actually read it. So basically, what I'm going to do here today is actually just gonna read the case and maybe try to get into a couple of things in relation to the case that it could be debatable. I would think. I would think that in the reading of this case, it could be determined commercial or both. You know, regular. I don't know. Right to travel case. United States Supreme Court case Hendrick versus the State of Maryland, 235 U.S. 610, 1915. United States Supreme Court, Hendrick versus State of Maryland, number 77. It was argued and decided on January the 5th, 1915. Okay. Um, Justice McReynolds delivered the opinion of the court. So, I'm just going to get right off into it and just kind of give you some opinions, my opinions, which in retrospect probably doesn't mean anything, but, if anyone has any opinions about this, please feel free to share because, this is an ongoing thing and it's an ongoing fight for all of us, to do what we're doing. And me personally, you know, I exercise my rights to travel freely without a license, registration, etc., etc. And after having read this case and then following up with the other mentioned cases that's herein in this case, it kind of makes you go, But again, like I said, I'll leave that up to you guys. You guys just, if you know and you can prove to me that, you know, that this is different from what it's actually reading, you know, uh, we'll go from there. You know what I'm saying? This isn't, listen, this isn't for anybody to discredit anybody or anything of that magnitude or to think you're better than somebody else or anything like that or that you have a valid point to prove or anything of that magnitude. We're not going to go there like that, okay? Basically what we're doing here is this is just something that's up for debate, discussion, friendly discussion. If you want to sit there and be a troll and name call and all that, that's actually cool because on the cool, that's what this channel is about. You want to get on here, you want to debate, you want to, you want to argue points and get your point across. That's what this is all about. That's what this channel is about. This channel is about allowing all you bootlickers, you trolls, and all that to get your points out, get your points across, and if they're valid points, they'll be made note. You know, and we might be able to actually do something about it. You know, here, but you know, like I said, this page here, this broadcast here is for everybody. I don't care, because the one thing that I'm not going to do with you guys is disrespect you. And I would hope that you would do that in return. Do not disrespect me. If you do not agree on something, then let's just agree to disagree. And go from that point. Now, What I am going to tell you is this. What I do have here is I have a document right here. I don't know if you can see that, but let me see if you can see that. If you can see that. Okay. Let's see. There we go, like that. Let's do it like that. So this is the Supreme Court defines the following terms as follows. Basically what this is this is a list of the definitions. Okay? A list of definitions that the Supreme Court has provided. Driver, motor vehicle, automobile, etc., etc. This is the RCW code for the state of Washington. Okay, I don't know if you can see that, but there, that might be it right there. And we'll get into this one, the RCW code, at another time. This one Title 49, the Transportation Code. Now, I don't know if you guys can see that, why that's reflecting like that. There we go. This is Title 49, the brand new Title 49, as you can see. I don't know if you can see that or not, but if you can't, let me know. If you can, awesome. This is the Title 49. And the Title 49 Transportation and other regulations relating to transportation, Subtitle 8, Chapter 3, Subchapter B, Subtitle B, Subchapter B, Part 390, Federal Motor Carrier Safety Regulations in general, Subpart A, General Applicability and Definitions. Okay, Title 49 Transportation, this was updated just this past couple of weeks on 5/2/2023. 49 CFR 390.5. Okay, again, what did I just say? These are the definitions of words. Now, I've had a lot of people come to me and come at me with, well, the Supreme Court never said this, the Supreme Court never said that. Yet it did. They did say that. For all of you that doubt what definitions are, you know, everybody's going in and they're using oh yeah, well, you know, you can find that in Black's Law Dictionary, etc., etc. Sure, you can find it in Black's Law Dictionary, and you can find everything that I'm speaking on definition wise in Black's Law Dictionary. But then you have these people that go and they decide that they want to use dictionaries other than Black's Law Dictionary, Bolivar's Law Dictionary, which you know, as long as it's a law dictionary, it's okay, as long as it's been approved by the Supreme Court. As a lot of people know, the Supreme Court is usually, whenever they make a definition, it usually goes into an edition of the Black's Law Dictionary. In reference to a few days ago, I believe it was, a gentleman confronted me and said something to the effect of Black's Law Dictionary no longer defines what motor vehicles are, what operators are, etc., etc. And I told him, I said, well, you know, in that respect, you know, I'll respect what you say because I'm not going to dispute what you say, but I'm going to go with what the law says, you know, because Black's Law Dictionary is not the law. And a lot of people think, oh, you know, what? No, it's not. It's a dictionary. It's a law dictionary that determines some of the words. However, whenever you're using certain expressions and definitions in law, though the additions may be newer and the definitions may have changed over time, you have to go back to the original definition. Okay? So I don't understand, all these geniuses get on here and all these so-called law people, they get on here, but none of them understand that whenever in question, the courts go back to the original definition of things and standing of things because there's procedures to follow. So it's not like they're just going to get on there and say, hey, this is this now, this is what it says. Nah, that's not how it works. However, anyway, with all that said, with what I just showed you, keep it in mind, I'm going to refer to some things while reading this case, okay? And maybe you'll see the connection. Maybe there ain't no connection. Maybe it's just me making it up. I don't know. But I'm going to leave that up to you guys. I'm going to let you guys to determine how that falls out. So, back to this case. Hendrick versus the State of Maryland, 1915. The case was decided on January 5th, 1915. The opinion was handed down by Justice McReynolds. Plaintiff in error was tried before a Justice of the Peace, Prince George County, Maryland, upon a charge of violating the motor vehicle law. A written motion to quash the warrant because of conflict between the statute and the Constitution of the United States was denied. He was found guilty and fined. Thereupon, an appeal was taken to the circuit court, the highest in the state having jurisdiction, where the cause stood for trial de novo. Upon the original papers, it was there submitted for determination by the court upon an agreed statement of facts grievously verbose, but in substance as follows. Excuse me. The cause was originally brought July 27, 1910, before a Justice of the Peace for Prince George County by the state against John T. Hendrick for violating 133 of the motor vehicle law effective July 1st, 1910. He is and then was a citizen of the United States, resident in Cormorant, found at 235 U.S. 610, 619 in the District of Columbia. On that day, he left his office in Washington in his own automobile and drove it into Prince George's County, and while temporarily there was arrested on the charge of operating it upon the highways without having procured the certificate of registration required by 133 of the motor vehicle law. He was brought before a Justice of the Peace and fined $15 for having been found guilty of the charge set out in a warrant duly issued. Now, today we understand that the Supreme Court has defined motor vehicles as commercial. And to further support that, it even says that in the federal motor regulations and definitions as of 5/2/2023. It classifies a motor vehicle as a commercial vehicle. The Supreme Court, in their definitions, also classifies a motor vehicle. Means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in a transportation of passengers, property, or cargo for hire. That's what the Supreme Court has said the definition of motor vehicle is. Okay? And as a matter of fact, let me go ahead and just get this out of the way so that we can clarify some things here real quick. So, because I don't want anyone to say, oh, you left this out or you left this out. No, I want to make sure that it's all covered very well. Okay, so federal regulations spe- spe- specifically states that a motor vehicle means any vehicle, machine, tractor, trailer, or semi-trailer propelled or drawn by mechanical power and used upon the highways in the transportation of passengers or property, or any combination thereof determined by the Federal Motor Carrier Safety Administration, but does not include any vehicle, locomotive, or car operated exclusively on a rail or rails, or a trolley bus operated by electrical power derived from a fixed overhead wire furnishing local passengers transportation similar to street railway services. Now, when it says car, it is not talking about a car, an automobile. It is talking about a locomotive, a train, like the trolley that's in San Francisco. That's what they're referring to. They're not referring to cars, so don't get it twisted. Uh, I just want to make sure that no one gets that twisted, because I had someone, it says right there car. No, they're not talking about automobiles. They're talking about trains. The deals where you can jump on and ride and go down to the road, or you're talking about the Amtrak, etc., etc. That's what they're referring to. So, but what I just read to you is the federal motor. That's the federal motor vehicle definition. What the feds say motor vehicle is. Okay, and that's as of just a couple weeks ago, 5/2/2023. Okay, so there's no disputing that. You could sit there until you're blue in the face. That came straight off and out of their manual. And I've showed this to you guys before in the past. This right here. This right here is Federal Motor Carrier Safety Administration's rules and regulations. Okay, this book right here. See that? Federal Motor Carrier Safety Regulations. This is the book you get when you go commercial. Well, actually, it's the book that's provided to you through companies when you hire onto a company as a driver or a operator. The company is actually considered the operator. You are the driver. So you are actually issued that book. Each truck is to come equipped with that book in it. Now you ask yourself one question. Do you or are you given that safety book when you purchase an automobile? Or are you given a safety book, period, for an automobile? No, you're not given one, because there never has been one. One was never published. The only book ever published for safety reasons, when you hear a lot of these cases that go in front of the courts, they're always talking about, yeah, well, it's a public safety issue. And now they're trying to integrate it into automobiles and things of this magnitude, and things like that. And they're trying to implement it into automobiles. They're trying to slowly integrate it into that. And if you pay attention to where the laws actually change, what you have to pay attention to is the wording of the law. The wording of the law is the part of what you have to actually pay attention to, because that's how they are slowly encroaching on into your rights by manipulating words into law. Okay, so just keep that in mind. I'm all over the place right now, but we're going to get further into this, because I don't really want this. It's already getting pretty long, and I don't want it to get too long. A motion to quash having been denied, whereupon he filed his appeal. At the time and place aforesaid, he had not procured the certificate of registration for his automobile, required by 133. Upon the foregoing, the court shall determine the questions and differences between the parties and render judgment according as their rights in law may appear in the same manner as the facts aforesaid were proven upon the trial. Either party may appeal. Now, you heard me just say it earlier. This is in the opinion that the judge handed down. He did actually use the term automobile. Okay? So keep that in mind, because this is in reference to automobiles and motor vehicles. Both are actually openly mentioned in this case. The Maryland legislature, by an act effective July 1st, 1910, Chapter 207, Laws 1910, page 177, prescribed a comprehensive scheme licensing and regulating motor vehicles. The following summary sufficiently indicates its provisions. The governor shall appoint a commissioner of motor vehicles with power to designate assistants, who shall secure enforcement of the statute. Before any motor vehicle is operated upon the highways, the owner shall make a statement to the commissioner and procure a certificate of registration. Therefore it shall bear a numbered plate. The certificate and plate shall be evidence of authority for operating the machine during the current year. 133. Registration fees are fixed according to horsepower, $6 when 20 or less, and I'm assuming that means 20 horsepower or less, $12 when from 20 to 40 horsepower, $18 when excess of 40 to 136 horsepower. No person shall drive a motor vehicle upon the highway until he has obtained at a cost of $2 an operator's license. Subject to revocation for cause found at 235 U.S. 610 620 137, any owner or operator of an automobile, non-resident of Maryland, who has complied with the laws of the state in which he resides requiring the registration of motor vehicles or licensing of operators thereof, etc., may under specified conditions obtain a distinguishing tag and permission to operate such machine over the highways for not exceeding 2 periods of 7 consecutive days in a calendar year without paying the ordinary fees for registration and operator's license. 104A. But residents of the District of Columbia are not included amongst those to whom this privilege is granted. 132. Other sections related to speed, rules of the road, accidents, signals, penalties, arrests, trials, fines, etc., all money collected under the provisions of the Act go to the Commissioner, and except so as is necessary for salaries and expenses, must be paid into the state treasury to be used in, now here's your scam right here. Here's part of your scam. In construction, maintaining, and repairing the streets of Baltimore and roads built or aided by a county or the state itself. Section 140A is copied in the margin 1 at 235 U.S. 610 621. Has anybody ever been out to the East Coast, to Maryland? Have you ever drove on those roads out there? They're horrible. So where's the money going? Again, it's a scheme. It's all scheme. And it even says it right here in the case. A scheme. Not scam. It's a scheme. A smoke screen is basically what it is. That's what they're telling you they're doing with the money. But this is, back then in those days, they assigned a commissioner who was probably lacing his pockets pretty well. So the plaintiff in error maintains that the act is void because it discriminates against residents of the District of Columbia, attempts to regulate interstate commerce, violates the rights of citizens of the United States to pass into and through the state, exacts a tax for revenue, not mere compensation for the use of facilities according to arbitrary classifications, and therefore deprives citizens of the United States of the equal protection of the laws. Now, I'm not even sure what facilities they're referring to, because they never actually tell you what these facilities are. I don't know if they're talking about rest areas, if they're talking about, gas stations along the highway, or what. But I'm assuming that's what they're referring to, or they're talking about probably Department of Transportation, utility buildings, facilities like this. Who knows what it is? Back in those days, it's hard to tell. But I will say this, in having read this case, and he was filing the discrimination deal, Unfortunately, I do agree with the part about the discrimination where he can't file the discrimination claim solely based on the fact that he's not actually from that area. He drove to this area and was arrested there, but he's not from that area. He was there visiting. So therefore, the discrimination claim that he has submitted, I would say no, because unless you live there and that claimed discrimination immediately affected you, you would have no right to make that claim on behalf of other people. If the statute is otherwise valid, the alleged discrimination against the residents of the District of Columbia is not adequate ground for us now to declare it altogether bad. At most, they are entitled to equality of treatment, and in the absence of some definite and authoritative ruling by the courts of the state, we will not assume that upon a proper showing, this will be denied. The record fails to disclose that Hendrick had complied with the laws in force within the District of Columbia in respect of registering motor vehicles and licensing operators, or that he applied to the Maryland Commissioner for an identifying tag or marker. Prerequisites to a limited use of highways without cost by residents of other states under the plain terms of 104A, he cannot therefore set up a claim of discrimination in this particular. Only those whose rights are directly affected can properly question the constitutionality of a state statute and invoke our jurisdiction and respect thereof. So, yeah, like I said, I agree with that because he's not from there. He was just visiting. So therefore, the act of discrimination that he is making a claim to doesn't effectively affect him because one, he doesn't live there. He lives somewhere else. But the point is you cannot go and file a claim on behalf of other people without their knowledge, one, and probably without their consent, I should say. And two, you not being there, you're just visiting. I don't know what the purpose of his visit was, if he was there for vacation, if he was visiting family and friends, or what the reason behind his being there was at that time. Not that it matters today, but at that time, yeah, you can't do that. So, and just so you know, they list a whole bunch of cases in relation to that discrimination. If you just want to just look at this case, just go ahead and look this case up, and it will give you the numerous amounts of cases that's involved. Okay, so back to it. The movement of motor vehicles over the highways is attended by consent, by constant and serious dangers to the public, and is also abnormally destructive to the ways themselves. Their success depends on good roads, the construction and maintenance of which are exceedingly expensive, and in recent years insistent demands have been made upon the states for better facilities, especially by the ever-increasing number of those who own such vehicles. As is well known, in order to meet this demand and accommodate the growing traffic, the state of Maryland has built and is maintaining a system of improved roadways. Primarily for the enforcement of good order and the protection of those within its own jurisdiction, the state put into effect the above described general regulations, including requirements for registration and licenses. A further evident purpose was to secure some compensation for the use of facilities provided at great cost from the class for whose needs they are essential and whose operations over them are particularly injurious. Well, there you go. See, so the money is going everywhere except for where it's supposed to be. It's supposed to be going towards fixing the streets, the roadways, but it's not. It's going to wherever they feel the needs are essential, and and the thing that got me about this case is where it says right here, a further evident purpose was to secure some compensation for the use of facilities provided at great cost from the class for whose needs they are essential. Class. Now we're being classified, we're given titles now. I mean, doesn't the Constitution say that you're not allowed to have a title of nobility? In absence of the national legislation covering the subject, a state may rightfully prescribe uniform regulations necessary for public safety and in order in respect to the operation upon its highways of all motor vehicles, those moving in interstate commerce as well as others. Did you hear that? It says interstate commerce as well as others, meaning what he referred to earlier as the automobile. However, if you read this law, it says that covering the subject, a state may rightfully prescribe uniform regulations necessary for public safety. Oops, my bad. There's your uniform regulations right there. This is the regulations. This is what they're talking about when they're referring to these cases. A lot of people don't realize that there's no such thing as automobile regulations. There's no such thing as automobile safety regulation. Yeah, you have the Public Safety Transportation Department, but that's not in relation to automobiles. That's more like trains, planes, and things of that magnitude. But you don't ever see anything in there about weight class for cars, or you being charged for a specific weight class. The gross governing weight of a motor vehicle for an 18-wheeler is subjected to 10,000 pounds and up. So I don't know. And to this end, it may require registration of such vehicles and licensing of their drivers, charging therefore reasonable fees graduated according to the horsepower of the engines, a practical measure of size, speed, and difficulty of control. Now, again, I've never seen a book given out to cars for any of that what I just read. But if you open this book, exactly what is written right there is in this book right here. It's in this book. Federal Motor Carriers, commercial. There is no book published on that. And if any of you out there know of a public safety book that's been published for automobiles, light trucks, Jeeps, SUVs, compact cars, family cars, let me know. Because I'm curious to know, because of all the years that I've purchased cars, not once have I ever seen or ever received a safety manual, which is one of the guises that the states use as its reason for implementing a driver's license, registration, etc., is for the safety of the public. Well, let me ask you this question. To what respect does a driver's license prove safety? How does having a driver's license secure safety? I've never heard of this. I've never ever known for that little card to actually secure someone's safety. You can go take a driver's test today, cause an accident tomorrow. Does that mean that I'm not a safe driver? And then, as long as you, here's the interesting thing about this. A lot of people need to keep this in mind. As long as you renew your license before it expires, when is the next time you take a safety test? And then, if you think about it, the test you're taking is not even a safety test. You can't eat unless you go to driving school, which it is not a requirement, and it should never have to be a requirement. Maybe for the young drivers, teen drivers and all, to get them to learn the ins and outs and safeties of the road. But, you're going to get in that car, A driver's license does not prevent human error. Human error is guaranteed. Everybody makes mistakes. Everybody has accidents. So a driver's license doesn't prove nothing, and if anyone can show me a case law that proves that a driver's license protected somebody and made them a better driver or a safer driver, show me a case law that says that, because I guarantee you 100%, I guarantee you there is no such thing. There is no such thing. That argument is really, if you believe it, then you follow it, but a driver's license doesn't guarantee you nothing. It don't guarantee you nothing. It doesn't determine anything. It doesn't do nothing. Okay? So anyway, measure of size, speed, difficulty of control. This is but an exercise of the police power uniformly recognized as belonging to the states and essential to the preservation of, listen to this, recognized as belonging to the states and essential to the preservation of the health, safety, and comfort of their citizens, and it does not constitute a direct material burden on interstate commerce. Now I'm going to stop right there because I wanted you guys to hear that part that I just said. Health, safety, and comfort of their citizens. To have a driver's license, a registration, and a plate on your car. How the hell does me having a registration, a plate, and a license do anything for health? How does it do anything for safety? And what? Comfort in knowing that if I cause an accident, you can go and sue the insurance company and get money that you never had. That must be the comfort, because again, if you really look at what this case is saying, it's all about money. The whole thing is about money. The reasonableness of the state's action is always subject to 235 U.S. 610 623 inquiry insofar as it affects interstate commerce, and in that regard it is likewise subordinate to the will of Congress. And at that point in the case, they actually list a whole truckload of cases. I'm not even going to get into them, but here's a case. Here's what the opinion said from Alabama case in Smith versus Alabama. He says, consideration was given to the validity of the Alabama statute forbidding any engineer to operate a railroad train without first undergoing an examination touching his fitness and obtaining a license for which a fee was charged. Sounds like a train, not a car. The language of the court speaking through Mr. Justice Matthews in reply to the suggestion that the statute unduly burdened interstate commerce and was therefore void adeptly declares the doctrine which is applicable here. He said, this is what Justice Matthews said, but the provisions on the subject contained in the statute of Alabama under consideration are not regulations of interstate commerce. It is a misnomer, I have no idea what that means, to call them such. Considered in themselves, they are parts of that body of the local law which, as we have already been, properly governs the relation between carriers of passengers and merchandise and the public who employ them, which are not displaced until they come in conflict with express enactments of Congress in the exercise of its power over commerce, and which until so displaced, according to the evident intention of Congress, remain as the law governing characters in the discharge of their obligations. Whether engaged in the purely internal commerce of the state or in commerce along the states. The prescribed regulations upon their face do not appear to be either unnecessary or unreasonable. But again, he's talking about rail. He's talking about railroads. He's not talking about automobiles or motor vehicles. That's Alabama. So, I don't even see how back then in the day, they was trying to get it to where, the train system would become, you know, commercial or whatever. I'm not even sure how that all goes. That's a totally different subject for a totally different time, and we ain't gonna get into all that. In the view of many decisions of this court, there can be 235 U.S. 610 to 624 no serious doubt that where a state at its own expense furnishes special facilities for the use of those engaged in commerce, interstate as well as domestic, it may exact compensation therefor. Now, see, when I read this case earlier, I must have overlooked this because I didn't see this part. So there it is. There it is again. Domestic travel. If you read in the Bill of Rights, and I can't right off the top of my head, all Americans born and naturalized in the United States of America have the right to free domestic movement. I do believe that's in the Constitution as well. It may exact compensation therefor. The amount of charges and the method of collection are primarily for determination by the state itself, and so long as they are reasonable and are fixed according to some uniform, fair, and practical standard, they constitute no burden or interstate commerce. And then they list a whole bunch of citings and authorities that cited. The action of the state must be treated as correct unless the contrary is made to appear. In the instant case, there is no evidence concerning the value of the facilities supplied by the state, the cost of maintaining them, or the fairness of methods adopted for collecting the charges imposed, and we cannot say from a mere inspection of the statute that its provisions are arbitrary or unreasonable. Again, I'm gonna assume, I'm just gonna go on a limb here and assume that the facilities they're talking about are rest areas. Now, I'm almost certain that the state does not provide money for that, that we the people pay for that. So I'm almost quite certain that that's, there's something going on there. There is no solid foundation for the claim that the statute directly interferes with the rights of the citizens of the United States to pass through the state and is consequently bad according to the doctrine announced in Crandall versus Nevada. 6 Law 3518L ED 745. In that case, a direct tax was laid upon the passenger for the privilege of leaving the state, while here the statute at most attempts to regulate the operation of dangerous machines on the highways and to charge for the use of valuable facilities. Now I'm assuming that a passenger, there must be they must be either talking about a train, a bus, or something of that magnitude. As the capacity of the machine owned by plaintiff in error does not appear, he cannot complain of discrimination because fees are imposed according to engine power. Distinctions amongst motor machines and between them and other vehicles may be proper or essential indeed, and those now challenged are not obviously arbitrary or oppressive. The statute is not a mere revenue measure, and a discussion of the classifications permissible under such an act would not be pertinent. Now, if I do remember correctly, and I'm just guessing here, when you look at a title for an automobile, it actually does have the gross governor weight of the vehicle on it. As a matter of fact, allow me, if you will, to pull the title out here. And just for my own, want to confirm that. Scale weight 4,906 pounds. Okay. So yeah. So there you go. So on the title, as if you're reading this, it's talking about engine size, power, things of that magnitude. The only thing that I've ever seen in relation to a charge, and this title that I just folded up and just put back in here, all it does is shows the weight of my automobile. It does not have the engine size. It doesn't have the class size and all that pursuant to this, you know. And this is a 2023, title. So none of this even goes in conjunction with what's going on today. You know, uh, distinctions amongst motor machines and between them and other vehicles may be proper or essential indeed, and those now challenged are not obviously arbitrary or oppressive. The statute is not a mere revenue measure. I beg to differ with that. 235 U.S. 610, 625, and a discussion of the classifications permissible under such an act would not be pertinent. There is no error in the judgment complained of, and it is accordingly affirmed. Okay, so that is the entire case. But here's a footnote that I want to read real quick. That is part of their vehicle code. 140A, any owner operator not a resident of the state who shall have complied with the laws of the state in which he resides requiring the registration of motor vehicles or licensing of operators thereof and the display of identification or registration numbers on such vehicles, and who shall cause the identification numbers of such state in accordance with the laws thereof, and none other, with the initial letter of said state to be displayed on his motor vehicle as in the subtitle provided, while used or operated upon the public highways of the state, may use such highways not exceeding 2 periods of 7 consecutive days in each calendar year, without complying with the provisions of 133 and 137 of this subtitle. If he obtains from the Commissioner of Motor Vehicles and displays on the rear of such vehicle a tag or marker which the said Commissioner of Motor Vehicles shall issue in such form and contain such distinguishing marks as he may deem best, provided that if any non-resident be convicted of violating any provisions of 104, 140B, 140C, 140D, 140E, and 1401 of this subtitle, he shall thereafter be subject to and required to comply with all the provisions of said 133 and 137 relating to the registration of motor vehicles and the licensing of operators thereof, and the governor of this state is hereby authorized and empowered to confer and advise with proper officers and legislative bodies of other states of the Union, and enter into reciprocal agreements under which the registration of motor vehicles owned by residents of the state will be recognized by such other states. And he is further authorized and empowered from time to time to grant to residents of other states the privilege of using the roads of the state as in this section provided in return for similar privileges granted residents of this state by such other states. So, in respect to the case itself, as we already know, the federal government, United States Supreme Court, have already defined what motor vehicle is. They've defined what an operator is, what a driver is. And as a matter of fact, let me go ahead and pull that out real quick. Let's see, here we go. Okay, so pursuant to that of the operator pursuant to the federal laws, right, it says see driver. So under the federal laws, it doesn't actually, whatever driver is, that's what an operator is. So they're saying that operator and driver are one and the same, basically, is what the federal laws are saying. So let's see what they say. Driver means any person who operates any commercial motor vehicle, period. Now you go to some of the state laws, and it says anyone in operation of an automobile, etc., etc. Now, how can the state have one definition, but the feds and the Supreme Court have another definition? And it's interestingly enough, the feds and the Supreme Court actually have the exact same definition, but the states do not. So, operator of a service car being the person who is licensed, privileged to have the car on the streets in the business of carrying passengers for hire, while the driver is one who actually drives the car for hire. Newville versus Union, Indemnity Company, 60 Southeast 2nd. Okay, so, motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power used for commercial purposes on the highways and transportation of passengers, property, or cargo for hire. Okay? So then when you come back over here you go, driver. Now, like I said, this is what the Supreme Court said. I didn't say this. So this is the Supreme Court, straight off their website. Okay? The term driver, in contradiction to a traveler, is defined as driver, one employed in conducting a coach, carriage, wagon, or other vehicle. Bulwer's Law Dictionary. Notice that the definition includes one who is employed. Okay? Today we assume that a traveler is a driver and a driver is an operator. However, this is not the case. It will be observed from the language of the ordinance that the distinction is to be drawn between the two terms, operator and driver. The operator of a service car being the person who is licensed. I've already read that. So, a traveler. The term travel is a significant term and is defined as the term travel, and traveler are usually construed in their broad and general sense, so as to include all those who rightfully use the highways viatically when being reimbursed for expenses, and who have occasion to pass over them for the purpose of business, convenience, or pleasure. Okay, emphasis added, 25th Amendment, Jurisdiction First, Highway Section 42T, page 717. Traveler, one who passes from place to place, whether for pleasure, instruction, business, or health. Lockett versus State. Travel or traveler refers to one who uses a conveyance to go from one place to another, and included all those who use the highways as a matter of right. Notice that in all these definitions, the phrase for hire never occurs. The term travel or traveler implies by definition, one who uses the roads as a means to move from one place to another. Therefore, one who uses the roads in the ordinary course of life and business for the purpose of travel and transportation is a traveler. And what does it say in there? The Supreme Court's definition: traveler refers to one who uses a conveyance. Now, it doesn't say that he can't use his own conveyance. It doesn't say what type of conveyance he could use. And it doesn't give the authority to the state to say you can or can't use this particular type of conveyance. You can walk, you can ride a bike, you can ride a horse, you can do this or you can do that. It doesn't give the state that power to do that. What it says is what it says. A traveler has a right to use conveyance. That's what it says. And I would assume that would mean conveyance of his own choosing. Now they say that they give the state the power to regulate. Okay, you get the power to regulate anything dealing with commercial. So far as from what I've been reading, all these cases when they're talking about engine sizes and weights and all this, that's what's found in this book. That's found here. All these things, these claims that they're making is found in this book right here. You do not get one of these when you buy a car. So, you know, like I said, it's up for everybody to discuss. You know what I'm saying? I'm gonna post this video here, so I want you guys to get on here, and tell me what you think. Like I said, I can provide the documentation because, like I said, I go online just to cross-reference things, but I'm mainly in a library and I'm always reading and always looking at things. And the documents that you see is what I've actually printed straight out of the books. Okay, so, and believe me, I have tons of them here. Tons of documents sitting here that come straight out of books that I've printed, word for word from the books. Don't believe half the stuff you see online. Half of that stuff you see online, man, it could get you in trouble. Now, I'm not a lawyer, and I'm not giving you this advice and telling you, hey, go out here and do this or do that. No, you use this as your own discretion. This is an educational thing. This is a thing that, it's been in dispute for a long time. And what we're trying to do is figure out, what can and what cannot be done, as far as we the people enforcing our rights. My goal is to make sure that in doing so, of enforcing our rights, that we don't get caught up. My goal is to see to it that if we are going to execute these rights, that we actually have a solid foundation to stand on. I've seen so many stuff that makes me come in conflict with a lot of things that are said, and I'm like, I don't know about that, So, with that being said, I would like to keep it in respective format, because if it can be proven that it can be done, someone's going to prove it eventually. I've read cases where one young lady's case, I've mentioned this in another video, her case was denied because of her wording. She got denied basically because she gave the state the right, authority to make an act, which if she would have never done that, they would have granted her case. But unfortunately for her, in that aspect, she did do that, and that was a case from back in 1986. So now there is another case that actually came out in 1999, which I am going to sit down and read. And once I sit down and read it, we'll have a discussion on it. And I will read the case and make a video on the case in respect to that. But just so you know, I did actually read a Oregon case that came out of Oregon that was just 2012 denial. So like I said, there's a lot of if, ands, and buts about it. So, but like I also said too, you have to know the definitions of the words, because it's all about the wording, and it's also about the technicalities. You make the mistakes, the courts will capitalize on. Okay, so like I said, until the next video, you guys make some comments, leave some comments on this video, and let me know what you think, and I'll comment back, and we can go back and forth and show our facts, and let's go from there and see where this goes. I'm kind of curious to know just how far along this Hendrick versus State of Maryland case goes. If you know of a case that actually supersedes this case, please by all means put that case down in the comments, and I'd like to see it, because I'd like to read it and see what it's about and see how it supersedes this case, you know. I didn't see anything in the case that suggested that it has been superseded by anything new pursuant to the new cases that were listed and the mass majority of cases that are listed in the case from that time. But I've read hundreds and hundreds of cases of newer that has never recited back to this case. So I'm wondering if maybe this case was buried on purpose to shoot down everything that's trying to go on today to another degree, or what, But like I said, uh, we'll figure it all out. This is Dark Angel. Hey, I'm signing off, man. You guys have a good evening. And, like I said, leave some comments, if you know anything different from what this case says right here that actually is better for the cause. Put it down in the comments. Let's see what you got. All right. So this is Dark Angel. Hey, I'm out of here. You guys have a good night. I've been on here too long. This video is probably way too long, but on the same strength, it's there. So like I said, this is for everybody who wants to argue, debate. You want to do it, let's get into it. Let's see what we got. Let's see what's going down. So we'll get at it at another time. Dark Angel signing out.